Good evening, Kenyans. They have a memorandum of advice on joining insolvency petition number E004 and E007, both of 2019, as an interested party about Mumias Sugar. And because I've seen this matter, I've realized I've noted enough evidence that I've collected as a member of parliament, and a member of parliament, and within which the Mumias Sugar is within my constituency. And by the virtue of the Article 21 of the Constitution, and for the reason that I'm a state officer, I have the duty to address the needs of the vulnerable members of my constituency, including the decision on whether or not the company should be liquidated. The matter of liquidation is a matter of public interest that concerns and affects the people of Mumias' constituency, and any detrimental decision will greatly affect the people who elected me to represent them, and therefore the need to champion their voice in this matter. And on this, by virtue of the Article 22 of the Constitution, I have the right to maintain an action in the event the economic rights of my constituents are being threatened. And by virtue of the Article 73 of the Constitution, I have the responsibility to serve the people of my constituency, including championing their interests in matters that affects them. At the court, I've realized that the court is being used as a master in making sure that Mumias Sugar does not continue with its operation. The matter that has forced me to go and dig much more on evidence enough so that I can present these matters that I'm going, the 14 points I'm going to read to the Kenyans to know, and so that the Chief Justice Martha Koome and his team must investigate this matter and handle, because they cannot sit aside and watch the inconsistency in giving orders, inconsistency in their judgment, and in everything. Number one, an answered question from the courts. Who verified the credentials of the creditors to establish the actual amount due to them by MSL, or even to establish if any amount is due at all before allowing the application in the court? The case of Tomo Jenda and Kimeto demanding over 800 million. How did the judiciary allow Tuma's application, as Tumas had no valid locus standi, to challenge the lease, mainly when Tuma's bid was defective and void ab initio, as he did not have the bid bond as required? Number three, how can a loser, West Kenya, challenge the lease by claiming that it was best placed to run Mumias as required by the judge in his ruling of 2019 November 2021? The receiver clearly established West Kenya as a dominant entity if given the Mumias list, and there was no need to involve competition authority in the bid evaluation process. Number four, while Sarai bid was second highest after West Kenya, amongst all the valid bids, and why a wrong impression given at every stage that Sarai bid was the lowest, it is important to note that there were two other bids below Sarai's bid offer, which were ignored, being the lowest. Number five, how did the judiciary allow Vatox to challenge the lease, which never included the asset claimed to have been secured by Vatox, as the Nucleus Estate and Sugar Mill were not part of the Vatox securities, as Vatox can only claim to have ethanol plant and cogen as their securities? Number six, why was it not made clear that all assignments from EcoBank and Proparco to Victoria Commercial Bank, VCB, and from VCB to Vatox were invalid, as the interlender agreement binding all lenders clearly gave the first right of refusal to KCB, and it was not observed? Who verified the authenticity of the assignment of debt from EcoBank and Proparco to Victoria Bank, and thereafter from Victoria Bank to Vatox? Were the assignment documents complete and without any anomalies? What was the source of the funds for all these assignments? Who verified whether the funds used for all these assignments were legal funds? When there was a stay on sale of Mumias assets, was the assignment of debt by Victoria Commercial Bank to a non-financial institution, VATOX, not deemed sale, which is in contempt of court stay order? Why contempt proceedings were not lodged against Victoria Commercial Bank in this regard? Who are the beneficial owners of VATOX? Number 10, if EcoBank and Propago and thereafter Victoria Commercial Bank and now VATOX are genuinely interested in Mumias, why have they not been funding the securities and insurance of their secured assets for all these years of receivership? Number 11, how could the judge interfere with the security of the secured lender by ignoring the receivership and appoint an administrator in contravention of the provisions of the insolvency